gentlemen, welcome to this side event on the occasion of the presentation of the resolution on the report on the abusive use of the Interpol system here at the Parliamentary Assembly. And I'm very happy to see a lot of companions being along with me in the last 2 years doing this report. I want to thank Mrs. Ludmila Kozlowska from Open Dialogue Foundation for organizing this side event. And dear Ludmila, I want to pass the floor to you for your introductory remarks, please.
Thank you very much for everybody who came here, who worked with us during these 4.5 years to reform Interpol. I have to say that thanks to efforts of PACE and many other institutions, we have a platform to discuss such huge problem and actually challenge for everybody who was any time placed of red notice or and was abused for political matters and prosecuted by authoritarian countries. And I want to thank to Mr. Fabricius for his really huge and really very important work for us, for civil society. It was just incredible input, and for every member of the parliament, of this house, who supported our politically motivated cases, who were prosecuted by Russia, by Kazakhstan, by Azerbaijan, Ukraine, and many other countries. Thanks to your efforts, every letter was a key to release these persons. I would like to give the floor to our speakers. Please pass the word. Thank you.
Thank you very much, Ludmila Kozlowska. Well, I would like to thank the Open Dialogue Foundation for the critical observation of the report and not just for the co-organization of this event. That's not concerning you, it's for the plenary debate. Well, I would like to thank Interpol in particular for supportive cooperation. It was a very pleasant way to work with them, even if we go on very sensitive issues. From my point of view, the Council of Europe and Interpol have worked constructively on a common goal, and that is the improvement of the global notice system of Interpol with better respect for human rights. The Interpol's General Assembly adopted many very useful reforms in autumn 2016. The new statute and the new competence of the CCF promise much better protection mechanism against the abusive use of the notice system. And I will use for sure the 1 year period after report to observe in detail what Interpol is doing, how it will implement the measures we recommend, and what situations are coming up after this report. Ladies and gentlemen, in particular, 3 aspects of my report I would like to mention in this short introduction. First, the sharp increase in the number of red notices, more than 13,000 in 2016, requires more financial and human resource for the audit. In addition to the demand for an increase in resources, the Legal Affairs Committee also dares to make a recommendation that the higher demand of financial resources should be covered by those national central bureaus, NCBs, which are proven to have issued the most abusive notice in the system. We should have a blacklist of unreliable NCBs. According to the law of other jurisdictions, we have it in the polluters pay system, such NCBs or the governments responsible for them should also be obliged to cover the budgetary costs of the more intensive controls that they have caused. Second, I also suggest keeping and publishing the statistics necessary for the polluters pay principles. This, on the other hand, has a certain deterrent effect. On the other hand, such information would also be a valuable decision-making tool for the recipient NCBs as to whether or not particular investigations should be carried on normally or with a higher caution, and whether they should conduct own investigations. More transparency with regard to the information and justifications of the individual decisions to be published. Of course, many of Interpol's information, especially for individual investigations, must be treated confidential. However, there must be exceptions under certain conditions in order to give target persons the opportunity to remedy suspicious moments against them in a fair trial. Furthermore, the principle of confidentiality should not be used as a justification for depriving the public of general principles and criteria applied by Interpol employees in assessing alerts. This does not apply if other principles of police work make confidentiality imperative. I am happy about their comments and following discussions. I would be very happy if Mr. Willem Browder on our table would take first the floor, present himself, and use the possibility to share his point of view.
Thank you for that introduction. I'm one of the poster children of how somebody can be a victim of red notice abuse, and I'm very happy with the work that Mr. Fabricius has done and with his colleagues here at the Council of Europe in highlighting, in particular, the issue of serial abusers of the red notice system, because my own experience has shown that that's a real problem. In a very short summary of what happened to me, I was once the largest foreign investor in Russia. I discovered and uncovered and exposed corruption in companies that I invested in Russia. And in response to that, the Russian government expelled me from the country, raided my offices, arrested a lawyer who worked for me named Sergei Magnitsky, put him in pretrial detention, tortured him for 358 days, and killed him 7 years ago on November 16, 2009. I've made it my business since he was murdered to get justice for Sergei. And the campaign that I embarked on has led to something called the Magnitsky Act being imposed by the United States, soon to be by Britain, by Estonia, and various other countries are soon to be also doing it. The Magnitsky Act imposes visa sanctions and asset freezes on human rights violators in Russia. The Russian government and Vladimir Putin was particularly unhappy with my activities, and in retaliation, in 2013, in May of 2013, the Russian government issued their first Interpol red notice for me. On that occasion, my case was fairly well documented, and unlike some of the other Interpol stories which you've read about or will hear about, Interpol reacted pretty quickly to my story, and Interpol quickly put together the Commission for the Control of Files, which is their sort of quality control division. They quickly concluded that the red notice that Russia had applied for was politically illegitimate and politically motivated, and they rejected it and removed my name from the Interpol system. That was a good result. That showed that, at least in theory, in very high-profile, well-financed cases like mine, the Interpol system works. But then, 2 months later, the Russian government applied again to Interpol for a red notice for me. It didn't require any action on my part at that point. The Interpol system worked perfectly at that point, and 2 days later responded that rejected the Russians' request. And we would have thought that that was the end of the story. But no, it wasn't the end of the story. The Russians were so eager to get me on the Interpol list that a year later they sent a delegation to Lyon, France, where the headquarters of Interpol is. The delegation insisted that Interpol listen to their arguments. Putin even invited that at the time the General Secretary of Interpol, Ron Noble, previous General Secretary, to his dacha to discuss me. And then the Russians formally applied to Interpol again in 2014. This time Interpol spent about 6 months reviewing the request, and then the Commission for the Control of Files at Interpol in January of 2015 rejected the Russians' request for a red notice a third time. Now, we would have thought that that was the end of the story, but it's not. The Russians have now made a fourth request to Interpol for a red notice for me. So why am I so pleased with this idea of the report, which about bad actors, bad state actors? Because my case is a perfect example of a serial abuser, Russia being a serial abuser of Interpol, not just in multiple cases, but of multiple times in one case. And when I testified in front of the Council of Europe, I made the recommendation that there should be some type of fine or financial consequence to those people who abuse Interpol to pay for keeping the system clean. And so I'm very happy to see that I'm sure others made the same recommendation, but this is a very important thing, and I'm very glad to see this in the report, and I hope that Interpol actually implements all of the report, but in particular creating a division or creating a blacklist where countries that abuse Interpol have to pay more so Interpol can police those countries. Thank you very much.
Thank you very much, Mr. Browder. It's a point. Stop. We have exactly 4 minutes per speaker. You are on 3 minutes and 53 seconds. It's perfect. I would invite Madam Anna Ursaki to tell us her position. Your 4 minutes.
Thank you very much, Mr. Fabricios. And my name is Anna Ursaki. I am a lawyer and human rights activist from the Republic of Moldova. And I want to especially thank Open Dialogue Foundation for the possibility for me to be here, because I want to share with you a very important information about the recent election of the Moldavian citizen, Vitaly Perlov, as the chairman of the request chamber and the supervisory and advisory chamber of Commission of Control Files of Interpol, with a 5-year mandate. Perlov presented himself as a lawyer with data protection expertise. I don't understand what it means, but I presume that no any other proper checks have been undertaken about his real governance. And especially including the declaration of his independence and impartiality. Because in Moldova, we people from Moldova know, and it could be easily verified by the internet, that Vitaly Perlov acted as the Minister of Justice during the communist regime in Moldova from 2006 until 2009, and while service of the regime of communists, Perlov has also taken part in quelling and prosecuting the peaceful protesters during the revolt of 7 April 2009, known as Moldavian Twitter Revolution, which resulted in very hard reprisals against all the demonstrators. This information is also freely available on internet and could have been checked before any nomination or subsequent approval. But back then, in 2009, I have to say that many illegal, arbitrary decisions have been drafted by Perlov personally. And nowadays, we Moldavians must expect that all the Moldova's abusive requests to the Commission of Control Files will be edited by the CCF chairman personally. Mr. Perlov is known in Moldova as the crony of Vladimir Plahotniuc, the oligarch who unipersonally controls the Moldovan repressive organs and law enforcement bodies, Prosecutor General Office, Ministry of Internal Affairs, National Anti-Corruption Center, Judiciary, and other institutions. Moldavian citizens know, and it's also easy to find such information in Moldavian media, as well as in international media, that Plahotniuc is the only real authority who could approve Mr. Perlov's nomination for Interpol. In 2013, I want you to know that Plahotniuc proposed Perlov for the position of the Prosecutor General Office. And this position is politically apportioned to the Democratic Party of Republic of Moldova, which chairman is Vladimir Plahotniuk. Previously, Vladimir Plahotniuk, or Vlad Ulinich by his second identity, has been monitored by Interpol for association to organized criminal groups. Since then, Plahotniuk, when Democratic Party come to the government, was using the repressive machine for reprisals against his political enemies and opposers. On Plahotniuk command, the Moldovan authorities has repeatedly requested Interpol to issue red notice when the Plahotniuk oppositioners managed to fly beyond the reach of Moldavian authorities. There is a plenty of information on present day about Moldova as a captured state, and unfortunately, I have to recognize that my state is captured. There are a lot of information about oligarch Plahotniuk and his influence of the law enforcement agencies in the country. As revealed in the reports of such international monitoring organizations as Freedom House, Global Research, Center for Eastern Studies, Transparency International, and others. And in international press, The Guardian, BBC, New York Times, Business New Europe, Deutsche Welle. Of course, you know about the statement of Mr. Torben Jagland, Secretary General of the Council of Europe, who on the 10th August 2015 said about Moldova that the state is still in the hands of oligarchs. The government must immediately begin purging corrupt officials from public bodies, and the Anti-Corruption Center, the National Integrity Commission, and the General Prosecutor Office must be set on independent footing. But the very important statement which Mr. Jagland made in 2015 is that this captured state must be returned to its citizens.
Thank you very much.
That's why I'm here, because I want my state back from the oligarchs.
Thank you very much, Madam Usaki. Your 4 minutes term is over since 1 minute, so I pass it further to Mr. Mukhtar Abniazov. At my right side, your 4 minutes term, and just as an information, in the corner down you have a clock. You can watch how long time you have to speak. Thank you.
Добрый день.
Good afternoon.
Я являюсь всего лишь одной из жертв, которые преследуются при помощи механизмов Интерпола.
I'm only one of the victims of abuse of mechanism of Interpol for political persecution.
Дело мое отличается тем, что Казахстан, режим Назарбаева, преследует меня, использует другие страны, в частности Россию и Украину.
My case is different from other cases of abuse of Interpol because Kazakhstan prosecutes me not directly but also within other countries, Russia and Ukraine.
Я 8 лет назад покинул Казахстан, занимаясь политической деятельностью.
8 years ago I left Kazakhstan because of my political activity in the country.
И за это время Казахстан как минимум 3 раза пытался похитить различных близких мне людей.
And during this time, Kazakhstan tried to at least 3 times to kidnap my family and close to me people from different countries.
Но 2 похищения были успешны.
Unfortunately, 2 kidnapping were successful.
И недавно похитили из Турции одного из моего сотрудников моего банка.
And just recently, this year, was kidnapping of one of my former worker of my bank.
И казахские власти его используют, чтобы дать, он давал показания против меня.
They use this person as a hostage in order to get from him testimonies against myself.
Против оппозиционных журналистов.
Against opposition journalists
И различных политических активистов.
and different political activists in the country.
И по этому делу сфабриковано множество уголовных дел.
There are many fabricated cases on the basis of these testimonies.
И Казахстан не скрывает, что новые преследования будут, опять же, при новых исследованиях будут использоваться механизмы Интерпола.
And Kazakhstan even doesn't try to hide that new cases will appear in the future. To place a person in red notice is quite easy for this kind of authorities. It's almost automatically done.
Но для любого человека, особенно политического оппонента, это долгие годы борьбы за свою свободу.
But for every person who is already on the list, it's a long way, long years to be excluded and to fight with it.
Я благодарен 10 странам, которые помогли и не поддались на давление со стороны Казахстана, России и Украины.
I'm really grateful for more than 10 countries who refused and opposed for political pressure from the side of Kazakhstan, Russia and Ukraine.
Общее количество преследований казахскими властями не менее 40 человек.
Because almost 40% are prosecuted for political reasons by Kazakhstan.
И из них 10 получили убежище и защиту в европейских странах.
And 10% already received political refugee status, or their extradition were refused in European countries.
Уверен, что отчет подготовлен господину Фабрицу. Первый очень важный шаг, чтобы сделать невозможным политическое преследование, используя механизм Интерпола.
I'm sure that the report prepared by Special Rapporteur Mr. Fabricius is a really important first step to exclude possibility of political abuse of Interpol in the future.
Необходимы реформы, безусловно, в Интерполе, чтобы был механизм компенсации тех, кого преследуют те или иные страны.
It is obvious that there should be some kind of mechanism for compensation for those victims of abuse of Interpol who were already suffered.
Моя цель, что в будущем не допускать таких злоупотреблений механизма Интерпола.
And my aim is to stop and to prevent such kind of abuses in the future.
Я хотел поблагодарить многих тех, кто присутствует в зале, которые помогали мне и моим соратникам в этой борьбе.
I would like to say a great thank you for everybody who supported and who are sitting nowadays in this room and protect myself and a lot of my family
Хотел
members.
особенно поблагодарить представителей Литвы.
I would like particularly to underline the input of the Lithuania country.
Сейчас недавно совсем средства массовой информации литовские принесли извинения тем людям, которые как бы тоже преследовались, и литовские СМИ неверно информировали, и они сейчас принесли извинения.
And even Lithuanian media, independent media, they did special press statement with asking to excuse for those who are unfortunately were, because of present propaganda, named as some kind of criminals. Thank you very much for your attention.
More Spanish Italian law members, destination justice and human rights initiative. Floor is yours. Yes. Again?
No, you have to turn up here. Thank you, Mr. Fabricius. Dear partners, dear colleagues, I'll make the use of my 5-minute time as much as possible. I'm here on behalf of Destination Justice. We are a social change organization fighting injustice based in Geneva and in Cambodia. We are delighted to be here to exchange the ideas to implement effectively the reforms that were adopted and suggested by Mr. Fabricius on his recent report and the recent statute and operating rules of the CCF. We first of all would like to welcome the report and all the work that's been done and the draft resolutions. And as first and foremost, we must emphasize that we do recognize the work of the Interpol in fighting transnational crime and also its work in the cooperation for the drafting of this report. That was very important. But in any case, given the possible impact that the Interpol's activity might have on people's human rights, we need to stress that the proposed reforms will guarantee, in the first place, that red notices, including the so-called island system, and diffusion will be issued respecting the legitimate and statutory Interpol purposes that are already in place. And secondly, that in case of abuse or errors, victims will have the right to challenge the system and be adequately compensated. And in that lecture, we proposed 3 sets of recommendations or considerations for the next year that is going to come, as Mr. Fabricius mentioned, during this first year we'll monitor. As a first set, concerning preventive measures of unjustified red notices or diffusions, on first place, we'd like to put in place appropriate procedures to allow the CCF to consult appropriately national and international bodies and authorities in a fast and effective manner, and therefore duly implement Article 21 of the CCF statute. Secondly, to allow the General Secretariat or the CCF, specifically its supervisory and advisory chamber, to re-examine directly cases when there is repetitive red notices requests, as mentioned in the report, and therefore bypass the national central bureaus. As a second set of recommendations concerning the effective remedies for victims and abuses of red notices or diffusions, we would like to urge and see in this next coming year, in the first place, that, as also mentioned, Interpol to be equipped with adequate financial and personal means for the newly created CCF request chamber, and so grant effective access to remedy to any person wishing to challenge a red notice or diffusion. Secondly, that the Interpol General Assembly to ensure that the CCF request chamber members themselves are people, persons of high moral character, independent, recognized experts in their field of competence. And thirdly, the request chamber to have established its proper working methods, so that will be important in the first year to see how these working methods work out. Set up the use of internet tools. Internet tools are critical in this aspect to allow online filings and requests. Foster exchange and collaboration with different NGOs, as it's been doing already. Establish a repository of its decisions and make known its functioning to the wider public. And thirdly, as a third set of recommendations, concerning the establishment of a fund for compensation, as has been mentioned, of victims of abusive or otherwise unjustified red notices. We agree with the necessity to set up this fund. However, we would like to mention to carefully consider this approach based on the causal responsibility, that is, the polluters pay, as alluded in the report, as this might lead to states' allegations of Interpol's partiality. Secondly, to consider that two well-known United Nations funds that are already set up, such as the United Nations Fund for Victims of Torture or the United Nations Trust Fund for Victims of Trafficking, to consider these practices as perhaps for the compensation fund of the Interpol. And thirdly, allocate the use of the fund so as to provide not only for direct compensation, but also give victims access to appropriate support such as social, economic, legal, and humanitarian assistance. Thank you very much for your time.
Thank you very much, Mr. Navarro Blackmore. Next, Mrs. Ludmila Kozlowska. Please.
Thank you very much. My presentation will be focused more on the concrete cases and recommendations to Interpol based on what already was done, just recent reforms, but also what kind of challenges we as a human rights organization working with cases from Moldova, Ukraine, Russia, and Kazakhstan, and Azerbaijan also are faced with. So what we observe that beside huge steps, which we are of course welcome from the side of Interpol, we notice that even if the person has nevertheless and tried to appeal to CCF and file the application to CCF with decision of the court where his extradition was cancelled and he has political asylum, anyway this person could be once again placed in red notice. And there is no actually at the moment any kind of mechanism written in a clear way how to stop it. And even more, if this person linked to other cases which are stopped in other countries which are not safe, and you have no possibility to achieve political asylum or to be protected in the court, for example, like in Emirates or other Saudi Arabia and other countries, in this case you became a hostage. And we need to find the way how we can put this kind of recommendation to exclude and to find the way how officially to remove this person from Interpol. We have such kind of cases at the moment in Israel with Jan Andreev. He's a Russian oppositionist who's tackled in Israel and cannot go around anyway. And we have such case in Russia with Azerbaijan refugee, Farid Yusuf, and we have such case of person who would love to be a political refugee, but he cannot even apply, with Anatoly Pogorelov, who is also one of the so-called from Kazakh citizens persecuted by Kazakh authorities in different countries. We also observe that the states which repeatedly violate Article 3 on the Constitution of Interpol should be deprived of the right to nominate their candidates of members of Commission for Control Files until the number of violations significantly decrease. So to be able to have these statistics, we also have to find and have public this statistic. How many cases was violated by which country, and are there any kind of improvements? And this is particular our concern about Moldova, because this country, we knew there are a lot of cases of violation of and abuse of Interpol, but nevertheless nowadays the chief of control of the Commission for Control of the Files, he is Moldovan citizen, and he is former Minister of Justice who was responsible for repressions. And what is also very important, and one of the main of our recommendations which we want to advocate during the next years, is to create an independent advisory body with a commission which would be formed of representatives of Parliamentary Assembly of Council of Europe, OSCE, European Parliament, United States, and human rights organizations. This will be some kind of independent body which will have authority to provide Commission with expert opinion on different various cases from different countries. What is also very needed is to make a clear way, alternative ways to access to justice that will allow to file appeals against Interpol decision with an independent judicial body. The provision regarding the possibility of filing a claim with a permanent court of arbitration should be included in Interpol Constitution or the statute of the Commission. All red notice and diffusion must be published on Interpol website. This would not create serious risk for the pursuit of genuine criminals, because they already know what they did and they highly will be wanted. But still, it is allow persons with refugee status or those who are politically active to escape situation to be catched on airport or any kind of crossing boards. And for us, as Open Dialogue Foundations, it will be highly important that there will be clear follow-up from the phase with real implementation of the reform of Interpol. So we need a clear also new report which will be follow of implementation reform of Interpol. Thank you very much.
Thank you very much. Next in line is Libby McVeigh from Fair Trials International.
Thank you very much, and thank you to Open Dialogue Foundation and to Mr. Fabricius for the invitation to participate. And firstly, I'd like to congratulate Mr. Fabricius and the Legal Affairs and Human Rights Committee, and indeed the Secretariat, for completing this report, which we at Fair Trials wholeheartedly welcome. We very much appreciated having the opportunity to contribute to the work leading up to the report. And while we will almost certainly be using the report going forward in our advocacy, I'd like to emphasise that I really think the process of drafting this report has already contributed to the process of reform within Interpol. I think it has served to exert pressure when it was needed, and we are very grateful for that. Fair Trials is an international human rights organisation, and we work to ensure that criminal justice systems across the globe operate fairly. And as an international organisation working on criminal justice, we focus a lot on cross-border justice, ensuring that international cooperation to fight crime operates in a manner which respects and does not undermine fundamental rights. Our casework is at the heart of what we do, and really it was our work with human rights defenders, journalists, activists who've been recognised as refugees, who suddenly found themselves on Interpol's Red Notice list, but without any means to find the often costly legal support needed to challenge these red notices. It was that work that really led us to address these issues. And we have worked on countless cases, far too many to mention, but they include Bahar Kim Yungur, a Belgian nationalist of Turkish origin, who was pursued by Turkey through a red notice following a peaceful demonstration in the European Parliament, subsequently arrested in Netherlands, Italy and Spain, all of which refused to extradite him, but still it took quite some time for us to convince Interpol to delete the red notice. Bahar's case is just one example of many of human rights defenders caught up in this system. We have seen cases from across the globe. There is not one clear leader in terms of those abusing the system, and so we have focused our efforts on promoting reform at the Interpol level. And this is a moment for, I think, cautious celebration, because as has already been mentioned, Interpol has introduced a number of significant reforms. The refugee policy, which prevents refugees from being subject to red notices, the reforms to the vetting procedure, increasing the capacity of the legal task force to review red notices, and the significant reforms to the CCF rules introduced at the end of last year, which Mr. Fabricius has already mentioned, which we believe have the potential to really strengthen the mechanism of redress which it provides. In terms of next steps and our priorities at Fair Trials, we have three main priorities going forward. First of all, we want to take time to really monitor the extent to which the reforms which have already been introduced are being effectively implemented. We share Mr. Fabricius' focus on implementation. We have started to develop a framework for monitoring the reforms, and we will be working with a network of civil society partners to monitor the way in which these reforms are being implemented. This task isn't easy because Interpol is not the most transparent organisation, and it certainly doesn't publish the data which we need to really see whether or not these reforms are having effect. So we will be calling on members of Interpol to really encourage the collection and publication of the data we need to see whether or not the reforms are being implemented. There are further reforms still required, and that's our second priority. The vetting procedure has already been mentioned, and I think that's crucial. We've talked about the lack of human resources, but from our opinion, there's also a lack of information available to Interpol. And so we are encouraging civil society organisations to work with us to make sure that Interpol is provided with the information it needs to make the right decisions on cases. That involves information about patterns of abuse of human rights defenders from different jurisdictions, but also engaging with UN mechanisms, the Special Rapporteur on Human Rights Defenders, the UN Committee Against Torture, to share information with Interpol. My very last point, I think it's an important one. As we make it harder for states to use Interpol systems, we should not be naive as to think that they will not find other mechanisms through which to export repression against innocent people, human rights defenders, journalists, activists. And so we are now going to be very alert to the need to monitor the different ways in which states are cooperating together, and to take the learning from the Interpol experience to try and make sure that those other mechanisms cannot be used as an alternative means of repression. Thank you very much.
Thank you very much, Mrs. Wade. Before I start the open discussion, I have two more short statements from persons who contribute a lot to this report and who should get the possibility to say a short word. First, Mrs. Hertha Däubel-Melin, former Minister of Justice in Germany and former chair of the Committee of Legal Affairs and Human Rights in the Council of Europe. Mrs. Hertha Däubel-Melin, please, the floor is yours.
How many minutes?
3.
Okay.
Yeah.
Thanks, Dr. Fabricius, and thanks to the organizers. Of course, we really welcome your initiative, and we thank you for the report, and I thank the Legal Affairs Committee. I can see some members and the head of the Secretariat for the firm attitude. Thank you so much. Why are we here? You see, together with my friends, US lawyers, Jeremy Margolis and Rob Bendelman, we have been involved in the very cumbersome and lengthy process of the deletion of the red notice to Mr. Neftslin. It was totally unfounded, and as Mr. Neftslin, as we know, was a member of the Federation Council in the Russian Duma, a funder of opposition politics, president of the Russian Jewish Council, and he is now an Israeli citizen. It took 11 years before this totally unfounded red notice could be deleted. And this means that in these 11 years, he had, as a wrongfully targeted person, to endure all the burdens that are the consequences of these red notices. And it took a lot of money and a lot, not really, of lawyers' support. And I can tell you, not many people have this means let's say, to defend them against powerful governments. And this is why the regulations and the attitude of Interpol have to be changed. Thanks to this report and thanks to all the propositions and proposals that have been made, of course we support them. But let me say, I only want to emphasize some more. We need more transparency. You see, in one of the recent informations, a lot of red notices have been taken out. No one knows why. And, well, one can suppose that they have been legally unfounded. But wouldn't it be better to improve the filtering system and not to put them into the red notice Interpol system at all? We say yes to that, and we feel it is absolutely necessary to give Interpol the organizatory means, meaning money and staff, to do that, and to improve the regulations. Secondly, we strongly recommend to give a red notice a time limit, and to look into it after this time, whether the government requesting it has taken action or following action. If not, a renewal should not be granted. Thirdly, there should be safeguards that red notices that are deleted, that they are not only efficient within the Interpol system, but as well followed by the member systems of the member countries of Interpol, because there is a weak position at the moment. And, well, fourth and last one, Dr. Fabricius and others, they propose to, well, introduce a more and a stronger human rights management into Interpol. We think this is absolutely necessary. Not only during the procedure itself, perhaps by an obligatory hearing in certain cases, but as well in the questions of recommendation after wrongful red notice have been deleted, and there is a need for that. Thank you so much, sir.
Our expedition attorney at law in London. Maybe you can tell us something about ongoing cases.
Certainly. Thank you for the opportunity to speak today. I'd echo everything that's been said about Interpol. I'd echo the comments with regards to the report. I welcome the report. I think we have seen change, but this is an organisation that remains, in my view, in practice, having something of a credibility crisis. We all need Interpol to be an efficient and effective system, but there are fundamental problems, particularly in political cases, which mean there is much more work to be done. I think one of the biggest difficulties that we have with the current system is that the CCF, which is set up as a quasi-independent body, is of course not wholly independent. And I welcome Interpol's steps with regards to recognise refugees. That has been a great step forward to see recognised refugees able to get speedy deletion. But the real problem is for individuals who are facing current political persecution, who may be considering making a claim for asylum, or maybe in the process of doing so. For those individuals, they face a situation where they may well have been publicly placed on Interpol's website. It may have been disseminated that they are a wanted person for a variety of offences. We've seen people accused of economic offences, even extremely grave criminal offences. Wholly unmeritorious accusation, placed on the website, public humiliation. For those individuals to then make a challenge to Interpol, they are required to make a submission to the CCF, who then, we understand, but of course another fundamental problem that still remains is that there's no public repository of information as to how Interpol interprets its own constitution. But we understand that information is then transmitted back effectively to the state of persecution for comment and for information which is then not disclosed to that individual. That is a fundamental breach of those individuals' rights in a refugee law situation. And it's a very difficult scenario to manage. And so we see situations where individuals face a terrible decision. Do they jeopardize themselves, family members, other associates in the country of persecution by submitting information which they know will be sent back? Or do they simply let the red notice sit there until they're able to resolve their situation separately? I think it's difficult to see how that can be resolved. It's difficult to envisage a truly independent body that may have the potential to become a difficult organisation of itself, but certainly the current system for dealing with very sensitive cases isn't fit for purpose. One case I can discuss, which we are involved in at the moment, is that of Renato Isati. He is a Moldovan politician. He is the head of the most prominent opposition party in Moldova, and has been for the last 3 or 4 years the most vocal critic of the regime in Moldova. As a result of that, he's come under extraordinary pressure. He has, in the past 12 months, been explicitly told by the powers that be that he must leave Moldova. Having refused to do so, that pressure has increased. He is now exiled from Moldova as a result of red notices that have been issued. We can't go into detail, I can't go into detail as to the case itself, but certainly the materials that we have seen, certainly the way in which those proceedings are being pursued against him, bear all the hallmarks of political cases. He has clearly been a prominent figure in Moldova. He clearly is a continuing thorn in the regime's side. But this is a prime example of the difficult cases I discussed before, and the problems which we heard about, 11-year delays for delaying cases, continuing reputational damage. It's a difficult situation, but there is reform. We hope to see more. Thank you.
Thank you very much, Mr. Gardner. Now we can start the open discussion. I have already 2 persons on the speaker list. Mr. Kandelaki, please. Because I don't know all the names, if you just show your hand, tell me the names to put them in the lists. I have you.
Thank you. I know we are very short of time, so very quickly, but of course I cannot avoid thanking Mr. Fabricius for spearheading one more initiative that really matters. It's really, really important. To my mind, to a considerable extent, the reason for this problem is the increased Russian influence, institutional influence in the Interpol. This is the core of the problem. Georgia has also suffered as a result, and you may also know that quite recently, first time in history, Deputy Secretary General of Interpol in charge of Europe is Russian Major General Vitaly Prokopchuk. In his official biography, it says that he has taken part in combat operations. That means in the war against Georgia on the sovereign Georgian territory. It's been a few months since Interpol has been regularly issuing red notices for Georgian officers of the Georgian Armed Forces or Special Forces of the Ministry of Internal Affairs, or some former officers. Decorated officers, not political, with NATO or American or in some cases German training. And according to what I know, this general has been involved. So it's clear conflict of interest. In 2013, Russia managed to issue a red notice for an acting member of parliament of Georgia, a prominent politician who was accused of coup attempt in Russia. The red notice was removed then, but, and this is a separate problem, Russia is regularly issuing bilateral extradition requests. So my colleague, Yuri Kargamazov, he cannot travel anywhere because Russia has ability to issue such requests in real time. Russia has ability, and we've discovered this in cases of these officers, colonels and lieutenant colonels, serious decorated people, that Russia has ability to monitor their border crossings and then issue the red notices in real time to an astonishing speed. So just a quick concluding point, cooperation with the United States government is very, very important in continuing with this extremely important initiative, and we are here to wholeheartedly support it.
Thank you, Mr. Kandelaki. Next, Mr. Eric Cross.
Yes, hello. First of all, I absolutely want to join in and thank Mr. Fabricius and everyone else who worked on this. I do find it an extremely important issue. And I hope that the members of the Council or the Assembly will start to realize how really important it is. I'm actually here with 2 hats in a way. I'm a member of the Parliamentary Assembly. I also was appointed as the ALDE spokesperson for this matter. I'm a member of the delegation of Estonia. At the same time, I've been on the same red notice list 3 times by the Russian request. They accuse me in piracy. They said that I have hijacked a ship in the Baltic Sea. Luckily, they had also, before that, they had accused me publicly in starting the Georgian-Russian war and planning to blow up a pipeline in the Baltic Sea. So I actually think that I'm a very dangerous person, indeed. I think they actually didn't think that this request would be taken seriously by Interpol, because had already been cleared after Russian media reports by the Estonian prosecution and police, and there were statements out everywhere that this is bullshit, excuse my French. So they sent a request to Interpol using a picture of me in my full military uniform with some decorations. And they did it, they promised to do it in January 2011. They did it on August the 8th, 2011, which is the anniversary of the Georgian-Russian war. So that was, clear mockery of the whole Interpol system and the whole process. Nonetheless, Interpol duly took this in, and it took me some effort, despite that I had the Estonian police, government, etc., supporting my case, to get me off. Right now, the third Russian request is still sitting in the Files Commission. I'm off the list, but the case is not closed. They have been reviewing it for 4 years. And I've been stopped. Now I have an Estonian diplomatic passport, so it's not that easy to take me off. But they have tried to stop me at least 4 times in several council member states. So to stop this personal story, what I want to say, 1 minute.
5 seconds.
5 seconds. 4. So this is not just a legal issue. This is actually a part of a systematic Russian aggressive approach towards Europe. It violates people's human rights, the rights that we all need to defend. It discredits Interpol. It pulls Interpol into being a tool of Russian misuse of basic freedoms.
Thank you very much.
And that needs to be stopped.
Thank you very much. Next, Mr. Zingeris. If possible, please resume to brief 2 minutes, because we have so much people wanting to tell us something. 2 minutes.
Thank you. I always have such remarks with yours when I'm starting my speech. I will do that even less in German type, not French type, German type, 2 minutes. And I would like to say that, Brent, it was done a great job by you in, well, it is too much what happened with Interpol. The critical misuse of red notice for political reasons by dictatorships, and its impossibility to, Brent, its impossibility to make a red line, which countries are democratic and which countries are dictatorships, and when the dictatorships are hunting their political opponents. And even in our European warrant order, I was for years head of Human Rights and Legal Affairs Committee in my country, and I would like to say that I was always involved bringing some guy from Cyprus who is a member of European Union country, and Russian Interpol warrants red notice was used last few months ago. We brought political refugee from Moscow. We'll get Lithuanian European Union papers, Kulachenko Nikita from Cyprus. Well, Cyprus was on the brink to give up to Russian ambassador efforts to bring this man to Moscow. You can imagine what will happen with him in Moscow. It was, and Lithuanian Ministry of Foreign Affairs issued papers, political refugee papers for him, and they don't react our political refugee papers. After our long discussion, Kulachenko was brought when we told that in Brussels we are going to raise this question against Minister of Justice of Cyprus, who now have huge investigation about his family relations to some offshore money. Okay, I would like not to continue about that. So, only one issue, very short. It's European warrant or European. This European warrant should be after that. After this today will be completed, Interpol Red Notice, fantastic report. We should start to think about European warrant article. Well, even inside of our European Union democratic community, we have cases like Dana Demescu, editor-in-chief of a Romanian newspaper, who died just recently, a few weeks ago, in jail, and his son hunted by Interpol, who is German citizen, in all possible very strange issues inside of European country, but not on the level of Russia. The last remark, when you talk, when Georgi Kandelaki was making his remarks, I just received a message from one of international headquarters that a Russian head of Interpol become a member of Interpol headquarters, member of the committee for the files. Can you, where is this? Yes, that's too complicated for
May
my
I just interrupt you for 5 seconds? You can continue after that. But I have to say
yes,
thank you to all of you, because I have to leave now, because
yes,
it
that was last.
new situation.